My name is Irene Marquez. I am 38 years old, a licensed financial analyst, and I have spent 15 years helping corporations protect multimillion-dollar assets from exactly the kind of trap I walked into on a Wednesday morning in my own kitchen. The documents were already on the table when I came downstairs. My husband, Conrad, sat across from me with his coffee, calm the way a man is calm when he has already decided how something ends. He slid the papers toward me and said, "Sign these today, or I will destroy you in court." He mentioned the penthouse. He mentioned my grandmother's heirlooms. He said my name like it was already past tense. My hands were shaking. My throat was dry. I picked up the pen. I signed. But as the ink touched the page, I saw something in the document that Conrad had not noticed. Something small. Something that would eventually cost him everything. The collapse of our marriage did not happen suddenly. I understood that clearly once I stopped trying to explain it away. Conrad and I had been married for 6 years. For the first 3, things were good, not perfect, but real. By year 4, something shifted. He became secretive about his phone. Unexplained overnight trips multiplied. He started talking about simplifying our finances, a phrase he used so casually that I almost missed how deliberate it sounded. He suggested we consolidate accounts. He said it was more efficient. He said it was what smart couples did. I was a financial analyst. I knew what consolidation meant in corporate settings. Somehow I convinced myself marriage was different. I let him move pieces around. Small ones at first. I told myself I was being a good partner, not a suspicious wife. I was wrong. Every small move had been preparation for one large one. He had been building this for over a year. After Conrad left the kitchen that morning, I sat alone with the signed documents in front of me and read them properly for the first time. My stomach dropped with every page. The first document was an asset transfer agreement. My penthouse, listed under both our names despite the fact that I had purchased it entirely with my own inheritance before we married. The second was a limited power of attorney granting Conrad authority over the joint accounts. The third was a financial separation agreement that looked standard until page 7. Page 7 contained a clause about voluntary relinquishment of separate property claims. It was buried between 2 paragraphs of legal language designed to make a person's eyes slide right past it. I had signed it, but the clause had a condition. It required independent legal acknowledgement within 30 days to be enforceable. Conrad had not mentioned that condition. I suspected he was counting on me never finding it. I read it 4 more times to make sure I was reading it correctly. I went to the penthouse 2 days later. Conrad had already changed the access code on the building's private elevator. I got in through the concierge, showing my original deed of ownership, and rode up in silence. The living room was mostly intact. But the display case in the hallway, the one that had held my grandmother's jewelry, my great-aunt's pearl earrings, the gold bracelet that had been in my family for 4 generations, was empty. Glass doors open. Velvet lining bare. I stood there for a long time. Those pieces were not valuable in the way Conrad valued things. They could not be converted into leverage or listed on a balance sheet. They were the physical record of women who survived things far harder than a bad marriage. And he had taken them. On my way out, I noticed the small recycling bin beside the kitchen island. A torn receipt poked out from underneath a takeout bag. I pulled it free and read the address printed at the top. I photographed it before I left. Within a week, the story Conrad was telling had spread through our shared social circle. He was measured and sad when he told it. He said I had become erratic, that the pressure of work had affected me, that he had tried everything before deciding separation was the only option. People believed him. Conrad was good at being believed. He had a lawyer's handshake and a politician's patience, and he had been cultivating those friendships carefully for years. 2 of my closest friends stopped returning my calls. A colleague I had known for a decade sent me a careful, distant email suggesting I take some time. Even the attorney Conrad had recommended I consult, someone he called neutral, turned out to have worked with his firm on 3 previous cases. I was being surrounded. Quietly, efficiently, completely. But on a Thursday afternoon, a woman I barely knew, a neighbor named Bet who had seen Conrad moving boxes, leaned close to me in the building lobby and said, "He's hiding more than you know." The receipt from the recycling bin led me to a storage facility in the eastern part of the city. I didn't go there yet. Instead, I started with the financial records. I still had access to statements from before the account consolidation, investment summaries, wire transfer histories. What I found took me 3 evenings to fully map. For 14 months, Conrad had been making small transfers to an account I didn't recognize, never large enough to trigger automatic alerts, always spaced irregularly. The account was registered to a holding company. The holding company had one listed contact, a woman named Petra Holst. I found Petra's name in a second place within 20 minutes. She was copied on an email chain Conrad had accidentally synced to our shared family tablet 8 months ago. I had seen her name then and forgotten it. I remembered now. Petra was not a business associate. The emails made that clear. And the financial transfers made something else clear. Conrad had needed me financially diminished before he could move forward with her. I did not call Conrad. I did not confront him. I did not tell a single mutual friend what I had found. Instead, I went quiet in the way that water goes quiet before it changes direction. I bought a new phone, cash, different carrier. I opened a personal email account on a device Conrad had never touched. I created a folder and began filling it. Bank statements, transfer records, photographs of the empty heirloom case, the receipt from the recycling bin, the tablet email chain, timestamped screenshots of every document. My professional life had trained me to build cases out of numbers. A missing decimal. A misplaced date. A wire transfer at the wrong time. I understood that evidence was not dramatic. It was patient. It accumulated quietly until it became undeniable. I worked every night after dinner, sitting at the kitchen table in the apartment I was renting while Conrad occupied my penthouse. He thought my silence was surrender. I let him think that. I found my attorney through a colleague outside my industry, someone Conrad had no connection to. Her name was Attorney Renose, and she had spent 12 years handling high-asset divorce and financial fraud cases. Her office was plain and neat. She did not decorate for comfort. She decorated for focus. I handed her the folder without introduction. She read for 40 minutes while I sat across from her without speaking. Twice she went back to reread something. Once she picked up a page and held it closer to the light. When she finished, she set the folder flat on her desk and looked at me. She did not look surprised. She looked the way experienced professionals look when something confirms what they already know about human nature. The asset transfer document has a problem, she said. She turned to page 7. She pointed to the clause I had already found. Then she turned to something I had missed on page 11. She said, "This may be illegal." The clause on page 11 was the one that mattered most. It referenced the penthouse as jointly accumulated marital property, a classification that was factually false. My penthouse had been purchased 4 years before our marriage using inheritance funds transferred directly from my grandmother's estate. I had the bank records. I had the estate documentation. I had the deed in my name alone, dated 14 months before our wedding. Attorney Ose explained what this meant. Conrad had misrepresented the legal status of separate property to induce me to sign a transfer agreement. Under state law, that constituted fraudulent misrepresentation in a marital contract. Combined with the coercive circumstances, documents placed in front of me without advance notice, no independent counsel present, verbal threats made immediately before signing, we had the foundation of a duress claim. The voluntary relinquishment clause requires independent legal acknowledgement, Ose said. He never arranged that. He was counting on you not knowing. She looked at me steadily. Proving intent is the real battle. But you have more than most people bring me. Something changed in Conrad the week after I retained Ose. I believe he heard through the network of mutual contacts that I had been asking questions. He didn't know who I had spoken to or what I had found, but he could feel the ground shifting. He started calling more. The calls were disguised as reasonable. He wanted to settle this cleanly, he said. He used the word amicable 4 times in one voicemail. Underneath the reasonableness, I could hear something tighter, more careful. Then he made a mistake. He sent a text message at 11:43 on a Tuesday night. I had already screenshotted and timestamped it before I finished reading. In it, he wrote, "You have nothing and you know it." Take the settlement, or I'll make sure you spend the next 3 years in court burning through whatever you have left. Ose read it the next morning. She didn't smile exactly, but something in her expression settled. That, she said, is what intent looks like in writing. The first mediation session was scheduled for a Thursday in February. I arrived early. Conrad arrived with his attorney, a tall man named Harmon Briggs who had a reputation for burying opposing counsel in procedural delays. He shook my hand without making eye contact. The session began with asset disclosure. Briggs spoke at length. I listened and said very little. Ose presented our preliminary documentation without drama, laying each page flat on the table in chronological order. 2 hours in, the tone shifted. Briggs asked to review the original asset transfer document. He read it slowly. He turned to page 11. He read it again. Then he looked up, not at Conrad, not at Ose, but directly at me. Ms. Marquez, he said, in a voice that had changed registers slightly, at the time you signed this document, were you given any opportunity to consult independent legal counsel before signing? The room was very still. I answered him honestly. I told him that Conrad had placed the documents on the table without warning, that I had been given no time to review them independently, that he had said, clearly and directly, that if I did not sign that morning, he would destroy me in court. I used the exact words Ose had advised me to use, because they were true. Coercion, emotional pressure, financial manipulation. I described the way Conrad had sat across from me, the way he mentioned my grandmother's heirlooms by name, as if he was prepared to take them regardless, the way my hands shook when I picked up the pen. Briggs listened without expression. When I finished, he asked Conrad a quiet question I could not fully hear. Conrad's answer was short. Briggs set his pen on the table. He requested a private recess. He and Conrad left the room together. Through the glass partition, I could see Briggs speaking in a low, continuous way and Conrad's jaw going tight. Ose looked at me. He's beginning to understand what his client actually did, she said quietly. During the recess, Ose and I reviewed what we had assembled about the timeline of Conrad's planning. The picture was not flattering to him. 14 months of financial transfers to Petroholst's holding company. A shell account opened 6 weeks before he first mentioned simplifying our finances. A consultation with a separate divorce attorney. We had the billing record. That predated his first mention of separation by 8 months. He had not decided to leave our marriage and then figured out the finances. He had planned the financial exit first, then staged the marriage's ending around it. The deeper we had dug, the worse the picture became. He had moved money offshore in small amounts. He had attempted to list the Penthouse as joint property on a refinancing inquiry, a document that contradicted his own claims in the asset transfer agreement. 2 documents. 2 opposite claims about the same property. Both signed by Conrad. Ose called it what it was, premeditated financial fraud. The Penthouse question was resolved before we ever reached full trial. Ose filed a motion challenging the asset transfer on the grounds of fraudulent misrepresentation and absence of independent counsel. With it, she submitted the full paper trail. My grandmother's estate transfer, the original deed, the bank records showing the inheritance funds used for purchase, and the deed date, 14 months before our wedding. Conrad's legal team had no counter-document. Because there was none. The Penthouse had never been marital property. He had simply stated that it was, in writing, to a woman he had deliberately prevented from reading the document carefully. The motion was granted in 3 weeks. When Ose called to tell me, her voice was matter-of-fact. The transfer is void, she said. The Penthouse reverts to sole ownership in your name. I sat with the phone in my hand after the call ended. He had built an elaborate trap around a foundation that didn't exist. He had been so confident I wouldn't look closely that he hadn't looked closely himself. The receipt I had pulled from the recycling bin led to a climate-controlled storage facility 40 minutes outside the city. Ose filed a court order for inspection based on the financial fraud proceedings. 2 weeks later, a county officer accompanied us to Unit 114. The padlock was cut. The door rolled up. My grandmother's jewelry was inside, each piece wrapped in soft cloth and placed in a labeled box, as if someone had been planning to keep them organized for a long time. My great-aunt's pearls. The gold bracelet. 3 rings I had not seen since before the marriage ended. Also inside, documentation from Conrad's offshore accounts, printed and stored in a fireproof box, and a handwritten note in Petra Holst's handwriting listing the heirlooms by name with estimated resale values beside each one. The storage unit shifted the case from civil proceedings into a different category entirely. Ose spoke to the county prosecutor's office that afternoon. Conrad's problem had just become significantly larger than a divorce settlement. Conrad's legal team reached out within 48 hours of the storage unit discovery. Briggs, who had notably not withdrawn yet, sent Ose a formal communication requesting a settlement discussion. The proposed terms were vague and weighted entirely in Conrad's favor. He would return the heirlooms. He would not contest the penthouse reversal. In exchange, I would sign a non-disclosure agreement and withdraw cooperation from any criminal inquiry. I read the proposal once. Then I called Ose and told her no. She said, I assumed. I'll respond accordingly. Conrad called me directly that evening. Not through lawyers, just his voice on my phone like the last 6 years were still intact. He said we could resolve this quietly. He used the word dignity, which was interesting given the circumstances. He said going further would hurt us both. I told him I wasn't interested in quiet anymore. The court date was already set. We were going forward. I walked into the courtroom on a Tuesday morning in April carrying nothing but a leather folder. Ose had the full documentation. I had done my part by building it carefully over 4 months while Conrad assumed I was falling apart. I testified for 2 hours. I was not dramatic. I did not cry. I presented the timeline the same way I presented financial analyses at work, in order, with evidence at every step, without embellishment. I described the kitchen table, the documents without warning, the verbal threat, the page 11 clause, the empty heirloom case, the receipt, the storage unit, the text message at 11:43 on a Tuesday night. I watched the judge's face as I spoke. She made notes at specific moments. She asked 2 clarifying questions, both about the timeline of the Shell account relative to Conrad's first suggestion of financial consolidation. I answered both from memory. I had reviewed those dates enough times that they lived in me like a second heartbeat. Across the room, Harmon Briggs had stopped writing. Briggs withdrew from the case on the 3rd day of proceedings. The formal reason, filed with the court, cited a conflict of interest discovered during trial preparation. The real reason, which became quietly known to everyone in that courtroom, was that Briggs had reviewed the full evidence picture and understood that continuing to represent Conrad meant standing behind fraudulent documentation he had now seen in full. Attorneys have ethical obligations. Conrad had apparently not given Briggs the complete story when he hired him. Briggs was not a dishonest man. He had simply been given dishonest information. His withdrawal was procedurally clean and professionally careful. But in practical terms, it meant Conrad was standing in a courtroom without a shield, with a judge who had been taking very specific notes, and a paper trail that contradicted every version of events he had offered. The judge denied the request for a delay. Proceedings continued. Conrad sat alone at the respondent's table, and for the first time since the kitchen table morning, he looked like a man who understood he had miscalculated. The judgment came on a Friday. The asset transfer was declared void in full, fraudulent misrepresentation, absence of independent counsel, duress. The penthouse remained mine. The heirlooms were ordered returned immediately, with a fine for improper possession. Financial damages were awarded based on the documented transfers to Petra Holst's holding account. Penalties were imposed for the misclassification of separate property in the transfer agreement. Conrad was ordered to pay Ose's legal fees. The criminal referral for the storage unit contents was filed separately and was not part of the civil judgment, but it was referenced. That process was ongoing and outside my control. I had cooperated fully and left the rest to the appropriate authorities. I sat in the courtroom and listened to the ruling read aloud. I kept my hands flat on my knees. I breathed slowly. But that wasn't the moment that stayed with me. The real victory had happened quietly, over 4 months, at a kitchen table in a rented apartment, building a folder 1 page at a time. The news moved through Conrad's professional world faster than I expected. Within 2 weeks of the judgment, Two of his firm's largest clients had quietly reduced their commitments. A business partner he had worked with for 9 years released a carefully worded statement about reassessing the partnership structure. Petra Holst had disappeared from his public life entirely. No more shared photographs. No more overlapping check-ins. The holding company had been dissolved. Whether their relationship continued privately, I neither knew nor cared. Conrad's social circle, the same people who had believed his version of me without question, went very quiet. Nobody abandoned him loudly. They simply became unavailable. Calls not returned. Events not attended. The way powerful social groups quietly rear out around someone who has become a liability. Then, on a Sunday evening in late April, my phone rang with Conrad's number. I looked at the screen for a long moment. He was crying when I answered. I had not heard Conrad cry in 6 years of marriage. He sounded small and exhausted and genuinely lost. He asked for forgiveness. Then he asked for closure. Then, when neither of those landed, he asked for mercy, which was the most honest request of the three, because it was the only one that admitted he needed something from me rather than offering something to me. He said he had made mistakes. He said he hadn't thought it would go this far. He said Petra was gone and the firm was suffering and he didn't know how things had unraveled so completely. I listened to all of it. Then I said, Conrad, you placed documents in front of me without warning and told me to sign or be destroyed. You took my grandmother's jewelry and stored it with resale estimates written beside each piece. You planned this for over a year while I was still in the marriage. He started to respond. I kept going. I don't have anger left for you. But I also don't have mercy. Those aren't the same thing. I told him I wished him clarity. I meant it. Then I made one final move that I had been planning since February. I sold the penthouse in June. Not because I had to. Not because it was damaged. But because living inside a place that had been the subject of a legal battle felt like wearing a coat that didn't belong to me anymore, even though it did. I sold it for $2.8 million, above asking, clean clothes, no contingencies. The buyer was a young couple who walked through it twice and stood at the floor-to-ceiling windows looking at the city with the expression people have when they recognize the place they want their life to happen in. I used part of the proceeds to establish a small legal aid fund for women navigating financial abuse in divorce proceedings. I did this quietly, through a community foundation, with no press and no announcement. I kept the heirlooms. I had a local jeweler clean and photograph each piece and store the documentation with my estate attorney. They would pass to my niece one day, as they were always supposed to. I found a smaller apartment with good light and started over. Power looked different after that year. Quieter. Less interested in being recognized. I went back to work 3 months after the judgment. My professional reputation had not suffered. If anything, colleagues who had watched the case unfold from a distance treated me with a careful new respect. I did not talk about it much. I let the work speak. I started sleeping fully again. I cooked dinners I actually tasted. I called my mother on Sunday mornings and talked about ordinary things without a current of dread underneath. The financial aid fund I had established quietly began receiving applications within its first month. I reviewed them personally on Saturday mornings with coffee, reading each one in full before passing it to the foundation's legal team. Conrad faced a separate process that I was not part of. The criminal referral moved forward without my ongoing involvement. I had provided my documentation. The rest was the court's business. I realized somewhere in those quiet mornings that I had never actually wanted revenge. I had wanted my life back. By October, Conrad had lost more than money. That was the part one had not planned for, because I had never been planning for him. I had only been planning for myself. His firm reduced his role substantially during the proceedings. 2 clients whose trust he had cultivated for years had moved their accounts. The professional network that had once surrounded him had thinned to a small, uncertain ring of people who weren't sure yet where to place their loyalty. He was not destitute. He would recover some version of his life eventually, the way people do when they have resources and resilience. But the life he had tried to build on the wreckage of mine was not available to him anymore. I heard this through a mutual contact I still trusted. I did not seek the information out. When I heard it, I felt almost nothing. Not satisfaction, not sorrow. Just a kind of settled clarity. The way the air feels after a long storm has finally moved on, and the sky is simply itself again. Freedom, I had learned, was not about watching someone else fall. It was about standing upright in your own life without holding your breath. I want to finish with the truth about how this actually worked, because I think people expect a story like this to end with a dramatic moment, a courtroom speech, a confrontation, a single day when everything reversed. It didn't work that way. It worked because I found one clause on one page and read it 4 times instead of once. It worked because I bought a cheap phone with cash and started a folder. It worked because I walked into an attorney's office with documentation instead of emotions and let the evidence carry the weight. I did not scream. I did not beg. I did not warn Conrad what was coming. I simply became more careful than he had planned for. He thought he had married a woman who would be too hurt, too ashamed, too isolated to fight back. He thought the version of me he had constructed for his social circle, erratic, emotional, unstable, was the version that would show up. He did not know me as well as he believed. I walked away with my penthouse proceeds, my grandmother's jewelry, my career, and my name intact. I walked away whole. And that, in the end, was the only victory that mattered.